The Minnesota State Retiree Council, AFL-CIO, is pleased to be talking today with Paul H. Anderson, a retired justice of the Minnesota Supreme Court, where he served for 19 years, and prior to that served 2 years as Chief Judge of the Minnesota Court of Appeals. Justice Anderson, why is there a vacancy on the United States Supreme Court right now?
There's a vacancy on the Supreme Court because Justice Antonin Scalia died. People know, I believe, that you have a lifetime tenure on the Supreme Court, so either you decide to resign or your tenure is terminated by death. And Justice Scalia unfortunately died earlier this year. And quite frankly, it was a bit of a surprise to people. I have some good friends who actually traveled with him in the Far East, Hong Kong, and Singapore within a couple of weeks before his death, and he appeared fine. And I saw him and visited with him in last October, and he felt fine. But the death of Scalia has created a vacancy on the Supreme Court.
Justice Anderson, in your legal opinion, what is the judicial legacy of the late Justice Scalia, and will it endure?
Okay, well, first of all, when you talk about Justice Scalia, you have to talk about his rather broad personality. You have to talk about his intellect. He was a very brilliant person. And you have to talk about his writing ability. And quite frankly, I think you have to talk about, he was a very friendly, easy, in many ways, person to get along. But that said, his main legacy on the court, or what I think he wanted to be, he viewed himself as a traditional jurist, but he espoused the idea of originalism. That is, that a justice in interpreting the Constitution can fathom the depths of the minds of the Founding Fathers and figure out what their intent was when they drafted the Constitution, and you could apply it to modern day views. I do not believe, in my own mind, that his idea of originalism is going to endure. I became, one, as a justice of a state Supreme Court. I had to read his opinions and interpret his opinions. I believe that he used the idea of originalism to transfer into his interpret of the Constitution what he believed it was. I mean, even his allies and friends on the court, were critical of how he tried to use this originalism theory, and already you're starting to hear commentators say that it's not going to endure. It was successful, I think, during his time because it served the needs of those who liked his outcome on the court, and it served his purposes, but I do not believe that it's going to have enduring sustainability for a long time in interpretation of the Constitution. And part of the reason for this is, I think, you look at some of the great justices of the court. You look at John Marshall and his idea of constitutional interpretation. Even Holmes, Brandeis, their view of the Constitution was that they looked forward. They look forward as to how the Constitution would serve us and be helpful in our modern day society and answer questions. The problem with Scalia, he looked backwards. And I'm not sure that that is the way that, I am sure. Our Constitution was drafted for the future and was to deal with future problems. And it's just not a theory to my mind that works. So I think that's his legacy, but in my own opinion, I don't think it will endure.
What does the Constitution say about filling a judicial vacancy on the Supreme Court?
Well, first of all, I will probably give you too long an answer. But our founders didn't trust government all that much. And so is that they created this Constitution, which is a limited Constitution, and then they divided the power that government had. They knew that the people who had the sovereignty had to transfer some power to those who would govern. And one of the three branches is the judiciary, and it was established for the very purpose to protect the people from the ill humors that may emerge from the people themselves. That's quoting Alexander Hamilton in Federalist 78. But they did want to insulate the justices from political pressure, so they made them lifetime appointments, and this is how it worked. They gave the power of appointment, the ability to nominate to the president, and then the nomination had to be done with the advice and consent of the Senate. And so it's well-established procedure. President nominates, Senate should then advise and consent. And here's where I think it's a very interesting turn of events. I think that President Obama was very much attuned to what his obligation was under the Constitution, and he didn't nominate someone who he would want, maybe would best fit his ideology and where he comes from. He said very publicly, my obligation is to appoint the best person under the circumstances. And he understood that the Senate was controlled by the Republicans. So he fulfilled his constitutional duty. He picked a traditionalist judge who is not activist, has a more narrow view of the interpretation of the Constitution, and now it's been sent over to the Senate for their action, but they're taking none.
President Obama has nominated Judge Merrick Garland to fill the position on the U.S. Supreme Court. But we'll have more about Justice Garland and the process in a later segment.